say the pledge this morning, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. Well, I didn't know we were. There they are. Okay. Okay, as we left off Friday, Ms. Merchant, you had submitted this Riley case for my consideration on your motion for directed verdict, or for the court to dismiss count 6. So is there any further argument on that?
Yes, Judge.
Okay.
Judge, I just want to perfect the record on that. Our motion was based on the statute that provides that the court can be the 13th juror, and the judge is always the weigher of the sufficiency of the evidence. So that's one of your abilities and your duties after the jury renders a verdict. So instead of a motion for directed verdict, now it's a motion as you're sitting as the 13th juror to weigh the sufficiency of the evidence. In regards to sufficiency, there's two arguments. There's the statute of limitations argument, that the state failed to prove beyond a reasonable doubt that the statute was told, and then there's also the venue argument. And Judge, it's our understanding, and we know that the jury focused quite a bit on venue, and that was one of their questions as to whether or not there was venue here. And in speaking with them, that was what they were essentially hung up on, whether or not there was venue, and they relied on the fact that Mr. Dukes was found guilty in Wilcox County of concealing to extrapolate that they could get venue in Irwin County. They believed fully that it happened in Ben Hill County, and we also believe that the evidence did not support that there was venue in Irwin County. And so our motion for you sitting as the 13th juror encompasses that as well, that there was lack of sufficient evidence to prove that there was venue in Irwin County for that last count. The authority that the court has is under, it's in the Georgia statutes, but it's under 5-5-20, 5-5-21, and then also we would further argue that under 5-5-22 that the admission of the Wilcox County indictment in the trial of this case was testimonial, and that's something that swayed the jury. And so based on that evidence that it should not have been admitted, that you now can sit as the 13th juror and decide that the evidence was contrary, or the verdict was contrary to the evidence. And so we would just ask that you, I say direct a verdict, which it's not a motion for directed verdict, but essentially that's what it sounds like. But essentially vacate the judgment on count 6, find that the state failed to prove venue, and the statute of limitations, Judge.
Thank you.
Thank you.
Any argument?
Not at this time, Judge.
Okay. All right. I've reviewed the case law you presented. I'm going to deny that motion. The jury heard it and they decided whatever their rationale was. That's up to them. I noticed the Riley case, that was a motion for directed verdict, or a pretrial motion for the court to make that finding. I'm not willing to disturb the jury's verdict in that regard. All right, both sides ready for sentence?
Yes, Your Honor.
All right. Ms. Hart, does anybody from the family of Ms. Grinstead desire to make any statements?
They do, Your Honor. Before we get into sentencing, may I ask, I do need to, we never placed it on the record, the exact exhibits that went out with the jury. Would Your Honor like me to do that now or after sentencing?
Sure.
Just so our record is perfected. Again, it was all by agreement except for 2 exhibits, but State's Exhibits 1 through 56 all went back into the jury room. State's Exhibit 57, let me go back, I apologize, that may not be accurate. State's Exhibits 1 through 4 definitely all went out. Through 56 definitely all went out. States 57 through 69 went out with the jury. 70 was never tendered. 71 did not go out with the jury. 72 was never tendered. 73 went out with the jury. 74 did not go out with the jury. 75 was never tendered. 76 through 117 went out with the jury. 118 through 132 went out with the jury. 133 did not go out. 134 did not go out. 135 did go out. 136 did not go out. I apologize. 134 was the actual physical phone and answering machine. That did go out. 137 did not go out. 138 did go out. 139 went out. 140 went out. 141 was never tendered. 142 and 143, which were the computers, did not go out. 144 went out. 145 went out. 146 went out. 147 went out. And then 148 through 167 went out. 168 went out. 169. 170 along with 170A and B. 170C was never tendered. 171 through 175 went out. 176, the defendant's Miranda form went out. 177, which was the audio CD, did not go out. 178 did not go out. 178 did go out, I apologize. 179 went out. 180 went out. 181, which was the defendant's written statement, did not go out. 182, which was a video, did not go out. 183 and 184 did go out. 185, 186 did not go out. 187, 188, 189 were never tendered. And I apologize, Judge, 179 also was never tendered, so it did not go out. 190 through 199 did go out. 200 did not go out. I believe 201 did not go out. 202, 203, 204 through 215 went out. 216 did not go out. 217 through 239. 217 did go out. 218 did go out. Trying to confirm, Judge. 225 through 234 went out. 240, 241 through 250 went out. 260 through 263 went out. 267 through 275 went out. 283, 284, 285 all went out with the jury. 286 did not go out. 287 and 288 went out over defendant's objection.
What was that?
287, 288, 289 are the three that went out over objection, Judge.
Right, what were they?
They were the letters to Zach Gerard from the defendant in this case. And then 290, 291, 292, 293 did not go out.
293 went out.
293 they were allowed to look at in the courtroom, but it did not go back into the jury room. That was the one they requested to look at. Neither the Wilcox County conviction nor Defense Exhibit 4, which was the certified conviction of this federal case, neither of those went into the jury room. They specifically asked to look at the Wilcox conviction. They were allowed to look at it out here, but it did not go into the jury room. And just as it relates to defense exhibits 1 through 3 went out with the jury. The only other thing, Judge, is we would like to request in this particular case, as Your Honor is aware, the remains of Ms. Grinstead were tendered into evidence and they did go out with the jury. Each of those has pictures of them. We would ask to be able to be allowed to substitute specifically pictures of the exhibits in order to take the remains themselves out of the physical evidence in this case. And what we'll do is we'll take new pictures so that the record would reflect exactly what went back into the jury room.
What do you propose to do with the remains themselves?
Judge, we still have at least one more case to try, and we don't know. In that particular case, it relates to the...
So you mean return them to remain in the custody of the state?
Of the state.
That's what you're asking?
Yes, Your Honor. Eventually, we do wish to return those to the family. Obviously, that's all they have left. But until the cases are resolved, they would remain in the custody of the state.
Any objection?
No, Judge.
Okay. All right. I'll hear from you then on sentence.
Judge, we have at least 2 family members who have requested to speak. One is Miss Connie, who'll be speaking on behalf of herself, and Mr. Billy. And then the next is her sister, Anita Gaddis. There are some friends who can come on right up there.
You can come on and have a seat down here, ma'am.
There are some family members
or
who
wherever
have...
you want to stand. It's totally up to you. All right. You can go ahead and be seated.
Before I swear in, Judge, we do have some some friends who have requested, and some other family members who have requested to be able to speak. I indicated to them that under the rules of victim impact statements, they did not qualify. However, for sentencing guidelines, the court is allowed to hear any evidence that it deems would be useful in order to do the sentencing, so I would let the court know that there are some others who wish to address the court.
Thank you.
Ms. Connie, let me get you to raise your hand for me, please. Do you swear or affirm testimony given before this judge will be truth, whole truth, and nothing but the truth? Okay. And you have a quiet voice, so let me just go ahead and get you to state your name for the record.
My name is Connie Grinstead.
And did you know Tara Grinstead?
She was my stepdaughter.
And who is Billy Grinstead?
He's my husband, Tara's dad.
And the statement that you're giving today, is this on behalf of yourself, you and Mr. Billy, or who is it on behalf of?
On behalf of me and him.
Okay. If you have something you'd like to tell the judge, you can go ahead and do that now.
Should I look at you or?
However you want to do it.
Okay.
Grinstead.
Anyway, my name is Connie Grinstead, and I'm here today to speak on behalf of Tara's dad and myself. October 2005 was one of the most painful journeys that I think any family could ever be faced with. There are words that are seared in our memories forever. Missing, disappeared, vanished, and murdered. For over 11 years, we went to bed every night wondering where Tara was, and we woke up every morning with the same question: where is she? We wondered if she was dead or alive. We knew if she was alive, she was being held against her will. And that caused even more anxiety because we knew then she was being abused. Through the years, any time we learned that remains had been found, it was devastating to us as we waited to find out if those remains were Tara's. Some days we even had hope that we might find her alive, because that had happened in other cases with young women who had been gone longer than Tara. But there were so many days when the heartache was so great that we could barely even function. Young children in our family were afraid to even go out and play because they thought if somebody took Tara, they might take them too. My elderly mother was so distraught over Tara's disappearance. She sat day after day with her face in her hands because she was worried and upset because we couldn't find Tara. My mother had a stroke and died 28 days after Tara disappeared. The workers in the home where she lived told me that they fully believed the stress of Tara's disappearance brought on that stroke that ended my mother's life in a matter of hours. Tara was reduced from a vibrant, successful, hard-working young woman filled with hopes and dreams. She was reduced to just a few bones and teeth. There was barely enough left of her to even fill a manila envelope. Then after she was murdered, load after load of wood was put on her as they burned her lifeless body. They tried to make sure there would be nothing left of her. What they did to her body after she was murdered spoke volumes to us about what kind of hearts they had. And then even weeks after she was murdered and her body had been burned, they laughed about it at a party. They thought it was funny. What kind of person could do that to another human being? It wasn't funny then, and it's not funny now. It's bad enough that we lost Tara, but to find that we lost her the way we did just made everything so much more painful for us. Tara was a good teacher. She encouraged her students to reach their full potential. She wanted them to be prepared for college or whatever career path they had chosen. She didn't just want them to do well in her class, she wanted them to do well in life. She was a teacher in life, and we believe she is still a teacher in death. We hope others will realize the consequences of choosing a life of alcohol and drugs, the consequences of murdering someone and burning their body, and the consequences of devastating the lives of those that she left behind. For anyone who has chosen that life or is even being tempted, we plead with you not to take that path. No good will ever come out of that for them or anybody that loves them. Tara lost her life, and that left a hole in our hearts that can never be filled. We will feel the pain of this loss for as long as we live. We are still left with painful questions. Did she know she was going to die? Did she beg for her life? Did she suffer? I don't think mere words will ever be adequate to truly express the deep sorrow and grief that we have endured for over 16 and a half years. Tara loved life. Her thoughts were always focused on the future. She always set high goals for herself, and then she worked hard to achieve them. She already had her master's degree and was scheduled to complete her specialist degree in just 2 months. She had already applied to a doctoral program. She had dreams of getting married, buying a house, and having children. She will never fulfill those dreams, and she'll never reach another goal that she had set for herself. All we can do now is hold those dreams in our hearts because we will never see her fulfill them. Tara was murdered 3 weeks before her 31st birthday. Her birthday presents were already bought and wrapped. Some of her Christmas presents were already bought. The defendant says he stayed quiet all those years because of fear of Bo. But Bo was in prison many years ago, and yet this defendant remained silent. He also wants us to believe that he couldn't bear to think that Bo may have stolen Tara's purse, and he felt it was his duty to return it to her. That didn't sound like fear of Bo to us. But then he did nothing when he thought Bo had killed her. Did he feel that stealing was worse than murder? It certainly sounds that way. We made the decision back in 2005 that we were not going to accuse or defend anyone because we did not know what happened to Tara. We stood firm in our decision up until the arrest of 2017, and even then, we did not criticize the defendant. We waited for this case to go to trial. But sadly, this case has been tried in the court of public opinion and on discussion boards and on podcasts for years. Some even tried to drive the narrative in the way they referred to as making it entertaining. There were even cross-country tours with Tara trivia questions. That hurt us deeply. We put a letter in the Ocilla Star every year from the time Tara was reported missing right up until the arrest in 2017. We pleaded and begged for information about what could have happened to Tara. In one letter, we even said, if it was an accident and you didn't mean to hurt her, please just tell us and we will stand with you and help you make things right. But the silence was deafening. His confession in 2017 seemed genuine and sincere, and he looked remorseful. Although he wasn't 100% clear on every detail, he looked like a person who was ready to do the right thing. But his testimony on the witness stand only seemed coached, well-rehearsed, and sought self-serving benefits. It was amazing to see how crystal clear his memory became after spending some time in jail. Billy and I are not spiteful, vindictive people, and we don't believe in hating anyone. but we will always hate what this defendant did to Tara and to all of us who loved her. We had made the decision that regardless of the verdict, guilty or not guilty, we would not make any statements to the media afterwards. We made that decision out of respect for both families. Unfortunately, the defendant's counsel and family did not grant us that same respect. In fact, the giggles and excitement they expressed when they did their interview would have been more appropriate if your football team had just beaten their biggest rival. There are no winners here. We were shocked when a member of the defendant's family said that she thought the defendant's words on the stand should give us peace, because at least now we could know that Tara was never coming back. And then she went on to add that the defendant didn't even have to tell us that, sounding as if it was somehow she considered it to be a gift that we should be thankful for. We would like to add to that list of things the defendant did not have to do. He did not have to participate in a murder. He did not have to burn her body. And he did not have to stay silent all those years while we were frantically searching for Tara. We pray that people will remember that the defendant was not the victim, Tara was. We lost a lot when we lost Tara, but she lost everything when her life was taken, a life that God had given her. We do not want the defendant to leave this courtroom today believing that anything he has ever said or done in regards to Tara from 2005 right up until today has ever been helpful to us or brought us any kind of peace at all, and it never will. Whether he spends his days in a building with bars on the doors or walks as a free man, we know he will never be free of what he has done. We pray he will seek and find God's forgiveness. His actions imposed a life sentence on us, one of great loss and sadness. Every day that we get up, we have to find a way to cope with what he did. Tara's voice was silenced forever when she was murdered. So we are here today to be her voice, and we humbly and respectfully ask this court to give him the maximum sentence. Even that would be less time than what we spent looking for her. Thank you for allowing our thoughts and feelings to be heard today.
Thank you, Ms. Grinstead. Any questions? Thank you, ma'am.
Is Your Honor willing to hear from friends as well? Just a moment.
This is it. Thank you. Good morning, ma'am.
If you could raise your right hand for me, please. Do you swear or affirm the testimony given before this court will be the truth, whole truth, and nothing but the truth? Okay, have a seat for me. And let me get you to state your name for the record.
Miriam Seeley.
Okay. And Miss Seeley, did you know Tara Grinstead?
I did.
How did you know Tara Grinstead?
She grew up down the street from me, and we went to elementary, middle, and high school together, and college.
Okay. Did you have something you wish to address to the court as it relates to sentencing?
I do.
Okay. You can go ahead and let the court know what that is.
Okay. There is no appropriate punishment for what Mr. Duke has taken from us. The pure evil acts you have done cannot be undone or forgotten. You have taken from this world one of the brightest souls ever to walk the face of the earth. Tara was one of the sweetest, most loyal, loving people to have ever existed on this planet. She is missed by all that ever had the pleasure of meeting her. Her smile could light up the whole world, and her laugh, that snorting laugh, was absolutely contagious. She loved with her whole heart and was my best friend and an added bonus member of my family growing up. She was loved by so many and will be missed every day because there is a huge void without her. I hope Mr. Duke lives the rest of his life begging God for forgiveness every day till your dying breath.
Would you like the court to know about sentencing in this case?
The absolute maximum.
Thank you. I don't have any questions that the council may have.
No, thank you.
Thank you, ma'am. Step down.
Your Honor, the last person who wishes to address the court is her sister named Gaddis.
Go ahead and be seated, ma'am. Be fine. Thank you.
Let me get you to raise your hand, please, ma'am. Do you swear or affirm the testimony given before this court will be the truth, whole truth, and nothing but the truth? Okay. And could you scoot up to the microphone for me? Can you state your name for the record?
Anita Grinstead Gaddis.
And how did you know Tara?
Tara was my sister, my only sibling.
Now, before you give, have you prepared a statement to give to the court today?
Yes, I have.
Before you give that statement, let me ask you, what was your mother's name?
Faye.
And is your mother still living?
No, she is not.
Was she also Tara's mother?
Yes, she was.
When did Miss Faye pass away?
June 2008.
And did Miss Faye ever have any information about what had happened to Tara prior to her passing
She did
away?
not.
Okay. If you've prepared something you'd like the court to hear, you can tell them now.
Yes.
Thank you.
On Monday, October 23rd, 2005, at 10 a.m., a phone call would change my life, that of my husband and son, and my mom forever. They can't find Tara. 4 words. They can't find Tara. 4 small words. They threw our entire family into a spinning cyclone that has lasted 16 years, 6 months, and 27 days. We are still living in that out-of-control spiral. Days turned into weeks, weeks rolled into months, months migrated into years. This continuous nightmare is our life. There's little refuge. Time heals some wounds, but others are still raw. Over the course of the last 3 weeks, reliving this heinous act that Ryan Alexander Duke committed has ripped open those wounds and doused him with acid. The damage that was caused to Tara's family by his criminal acts can never be undone. The best we can hope for is to one day make peace with the emptiness that was once filled with Tara. She is no longer walking in an earthly body, but in a heavenly body, hand in hand with our mother, Faye Grinstead. Ryan may have desecrated her physical body to nothing but ashes, but he did not erase her memories from our mind, her voice from our ears, and her love from our hearts. Edmund Burke said, "There is no safety for honest men but to believe all evil of evil men. Evil men do not always snarl. Some smile charmingly. Those are the most dangerous." Ryan Duke is that kind of evil. He is an introvert. Bo Duke's an extrovert. Ryan is sneaky dangerous. Bo more open about the danger he exudes. Evil comes in all shapes and sizes. The vile human that is the defendant sitting at the table in the front of the courtroom is a perfect and prime example. His statue is rather small, but the demons in him are huge. In the 40 years that I have worked in the medical healthcare field, I've encountered many, many people with addictions of all kinds. In fact, my husband, Dr. Larry Gaddis, dedicates part of his medical practice to addictionology. I'm sure everyone in this courtroom today has known many alcoholics. But do they make a habit of breaking into people's houses just to steal $20? I don't think so. What about the addicts who are hooked on prescription medication? How many of them help to move a human corpse? None of the ones I've ever been acquainted with have done anything remotely offensive. Unfortunately, in today's society, so many of us have known folks who are addicted to street drugs, crystal meth, cocaine, etc. Of all of the ones with those problems who have crossed my path, I have never, ever, ever known one who burned a human body. Ryan Dukes used all of these excuses for why he participated in this crime. That and the fact that he was afraid of Bo Dukes, his very best friend for over a decade. A friend that he states petrified him so much that they actually lived together during most of that time. When Ryan testified last week and was asked why he was telling his version of the truth now, he answered, because Bo is in prison. Bo Dukes was convicted on federal charges and sentenced to 27 months of prison time in 2013. He was not released until 2017. I would like to ask Ryan why he did not come forward at that time and confess. Bo was in prison, so this excuse of fear just does not cut it. Had Ryan come forward even in 2013, that would have been 4 less years of torment that Tara's sister, family, had to endure. Ryan did not even come forward in 2017. He was caught. He confessed because he got caught. There is nothing sanctimonious about that. Ryan Duke used the word cremate. Cremate. Did he think that would make what he did seem less severe? Licensed funeral directors, embalmers, cremate. What he did was burn a body, the body of Tara Grinstead, by piling truckloads of pecan wood on her and struck a match. His choice of words do not make the severity of the crime less atrocious. Ryan's actions were so repulsively extreme that Tara's mere existence was reduced to less than 10 bony, fragmented pieces. Our family has no body to bury. We have no gravesite in which to establish a headstone. We have no urn where we can place seasonal flowers to honor and remember her. While showcasing her personal and private life in this very courtroom over the last 3 weeks, and all over the live streaming media stations. The defense attorneys did not want Tara's excellent character to be mentioned. I was in a Zoom meeting and heard one of Ryan's counsel, who also requested that teacher and beauty queen be omitted. They had no problem calling witnesses to the stand to talk about what a good guy Ryan was. Well, Your Honor, I would like to tell the court who Tara Grinstead was. I have Tara's embossed Bible with me today. On the inside, it reads, "Presented to Tara Grinstead by Larry, Anita, and Gabe, Christmas 1993. And in Tara's own handwriting, it says, "Baptized December 24th, 1990 at First Baptist Church, Hawkinsville, Georgia." Tara was a Christian. That's who Tara Grinstead was. As an 18 to 19-year-old college student, one of her first jobs was working in the nursery at our church in Hawkinsville. Tara loved children. That's who Tara Grinstead was. In this Bible, I found a note to Tara. "Thanks for giving the children a week of real adventure in God's world and word." And on the back, it says, "Vacation Bible School, June 1994. Tara loved the Lord. That's who Tara Grinstead was. During the months that our mother, Faye Grinstead, was undergoing chemotherapy for stage 2 breast cancer, Tara was a full-time college student and had a part-time job. Even with her busy schedule, she still did everything humanly possible to make those treatments and the side effects more bearable for our mom. Tara was an exemplary daughter. That's who Tara Grinstead was. Last week during the trial, a young lady stopped by my car. She introduced herself. She is a county judge in Irwin County with an office in this very building. She told me she had Tara as a teacher twice in high school, both times for history. She stated that Tara saw all students in her class, not just those who were popular, not just the athletes, and not just those who were easy to teach. Her exact words to me, and I quote, "I am a judge today because of Miss Grinstead." Tara was a dedicated teacher who was adored by her students. That's who Tara Grinstead was. Wendy McFarland was a co-worker at Irwin County High School and a very dear friend of my sister's. Wendy was steadfast in helping our family and this community amid multiple searches throughout Irwin County in 2005 and 2006. During many of the national news interviews that Ms. McFarland participated in over the years, she consistently said, "Tara not only supported athletics at Irwin County High School, but also the arts and drama, which is what I teach." Last Thursday, Wendy walked into this courtroom to hear closing arguments. Wendy has terminal cancer. She had just undergone chemotherapy treatments on Tuesday. She was in attendance to support Tara. Her words to me were, "I loved Tara. She is worth me sitting here uncomfortable and in pain. Tara deserves that." Tara was a faithful and devoted friend to all who knew her. That's who Tara Grinstead was. Your Honor, I could go on and on and on with stories of this nature from dozens of people, but I will stop at this point because hopefully I have touched briefly on the character of my sister that was not allowed during testimony. I cannot even begin to speculate concerning the dollar amount spent by the city of Ocilla and the county of Irwin during the first few years after Tara vanished. Within just the first few weeks, there were helicopters in the air. K-9 units from all over the southeastern United States were here in Ocilla, on the ground, searching. Giant billboards were erected in Ocilla, Fitzgerald, and on I-75 in Tifton. A command center was set up at the Irwin County Senior Center. Hundreds and hundreds and hundreds of volunteers, including law enforcement, first responders, civil defense, teachers, friends, family, trekked through revolting terrain looking for Tara, while Ryan Duke smugly sat in his home in Fitzgerald, knowing these extensive and costly searches would be in vain. Ryan Duke has been in jail for 5 years at the Irwin County Detention Center. Personally, I have lived in a prison of hell for almost 17 years. To be more specific, 6,053 days. 6,053 days, Ryan Duke. The maximum he can serve on the charge of concealing a death is 10 years. That's only 7 years less than the sentence that I and the rest of Tara's family and friends have experienced due to his revolting and villainous action. Ryan may have acquitted on several charges, but does that make him innocent? Absolutely not. Not by any stretch of the imagination. Judge Reinhardt, I want to voice my sincere gratitude for the court allowing me this opportunity of expression. Speaking on behalf of so many who loved Tara, it is our feeling that the legal system failed my sister. If the legal system did indeed fail Tara, I implore you, Your Honor, not to let the justice system do the same. Tara deserves and needs justice for the crimes that were committed against her. I respectfully ask this court that they give Ryan Alexander Duke for the crime concealing a death of another the maximum penalty as required by law. Thank you, Your Honor.
Thank you. Any questions, Ms. Merchant? No, Judge. Thank you, Ms. Gaddish.
Thank you.
Anything further, Ms. Hart?
No further evidence or
Is
victim impact statements, Your Honor.
No further evidence, you say? Does the state desire to present any evidence as it relates to restitution or anything like that?
No, Your Honor.
Okay. All right. As to sentencing, anything you'd like to present or argument you'd like to make, Ms. Merchant?
I would like to present the letter that the court received and the state received from the warden at the jail currently, and then other than...
I'm going to hand that to the clerk, and it'll be made part of the record.
Thank you, Judge. Other than that, we'll just have argument we'll reserve till the end.
All right, anything further from the state as to sentence?
Yes, Your Honor. We're asking the court to impose the maximum in this case, 10 years. I don't think I could say it any more eloquently than her family has said it. For nearly 12 years, from October 24th of 2005 until February of 2017, this family and this community searched for Tara. It's not just the money, but it's the pain of waking up each day and going to bed each night not knowing. That is a different kind of pain. Having worked with this family, frankly, since 2010, I can tell the court that it is a different kind of pain that they suffered when they did not have any answers. And so for that reason, we're asking the court to impose the maximum of 10 years. Again, I can't put it any more eloquently than they can, that they're going to live with this the rest of their lives. But even based on just his actions, just what the jury has convicted him of, which is the concealing a death, they had nearly 12 years without answers, 12 years without knowing, 12 years of living in their version of a prison. And so we're asking the court to impose the maximum, which doesn't come close to what they suffered.
Thank you. Ms. Merchant.
Thank you, Judge. Yes. Judge, the reason that we didn't present evidence is because during the trial, the court heard the evidence in this case and heard about Mr. Duke's good character, Ryan Duke's good character, and heard from members of the community, and also heard from the jury. And I think the jury verdict is one of the primary things that the court needs to consider in determining the appropriate sentence. A lot of the victim impact statements are focused on the charges that my client was found not guilty of. And I know that there's an argument about whether or not he should be held accountable for the murder of Miss Grinstead.
It's not what they found him guilty of.
And that's not what they found him guilty of. And beyond that, I think that it's important for the court to consider when determining a sentence, an appropriate sentence, that what the jury spoke and what the jury wants, and because that's the community. Because your role is to determine what the community wants, what the community wants as far as a sentence. That's one of the things that you have to consider, and what the appropriate punishment is. Sure. So Mr. Duke has been in custody since February 2017. The first, a little over a year, almost 2 years, he was on suicide watch. You heard testimony about that. He was in conditions that required him to be completely isolated. He has had absolutely no infractions. You've got a letter from the warden that says he's had absolutely no infractions, essentially a good conduct letter, that specifically says his good demeanor and presentation are notable. He was a model prisoner. He has been there for over 5 years in custody. He has waited patiently for his day in court, waited patiently for his exoneration by the jury of the charges that the state has rendered against him. He went through 3 appeals. He sat patiently through 3 appeals. He sat patiently through COVID. He himself was willing to waive his right to a speedy trial in order to not have the jurors be subject to coming here during COVID. He sat patiently during that time for his truth to be told. And your consideration for sentencing is him as a person and the role that he was found guilty of. The role that he was found guilty of is moving Miss Grinstead's body with Bo Dukes. It is not for harming her. It is not for murdering her. It is for moving her body after Mr. Dukes had already murdered her. It is for that role. He is not the one that sat out there and burned her bones for a week. That is Bo Dukes. He is not being held responsible for that. And so the appropriate punishment is not for what Bo Dukes has done. It is for what Ryan Duke has done, and for remaining silent for all those years and for not coming forward. But he's told you why he remained silent. He has told the court, he has told the jury, and the jury believed him. The jury spoke and believed what he told them as to his reasons that he has remained silent for all these years. Judge, I'd just like to also put on the record and just let the court know that that depending upon the sentence, he is willing to accept responsibility for that, despite the fact that those charges happened in Ben Hill County, and you heard our argument about that. He's willing to waive any issues on that. He's willing to waive the continued, appeals on this and things like that, and take responsibility in exchange for an appropriate sentence.
And Judge, that would be an appropriate argument for the court to consider. That's something that we certainly could discuss with us, but it's completely inappropriate to argue that to the court.
Yeah.
We have
Are you saying that if I give him time served, you won't appeal? What's the point of your argument?
No, Judge, that's not it. And we have had that appropriate conversation. But one of the things, so we unfortunately in Georgia don't have sentencing guidelines, but the federal court does. And so when you look at the federal court sentencing guidelines, those are the factors that we have to consider. One of them is judicial economy. One of them is acceptance of responsibility. He took the stand and he accepted responsibility for his role in this case.
Yeah, but he waited quite a while before he did accept any role.
Right, Judge.
Until knowing all this time.
Right. And he explained why he did that. And the jury believed him. He explained why.
And convicted.
Right. He explained why he waited so long. And they convicted him for, and the act that they convicted him for, though, I think is important to note, because the punishment has to fit the crime. The punishment has to fit what he was convicted of. And he was convicted of moving, with Bo Dukes, moving her body from one location to another. That is what he was convicted of. And so that's what you have to determine is appropriate for sentencing.
And never saying a word.
And never saying a word, exactly. And the reason why he never said a word, that's important as well. The reason that he never said a word is important to sentencing, and why he didn't come forward before all of these things happened. And I know there's speculation as to why he didn't come forward or could have come forward, but he told us on the witness stand why he didn't come forward.
And the jury could have exonerated him on that excuse alone.
They
Right?
could have judged.
They could have found that that's a good enough reason not to come forward, so we're going to find him not guilty on that. He didn't willingly conceal the debt, right? They could have done that.
They could have, and the reason that they found him guilty on that was they believed that it was
I'm
in
going
Ben
to
Hill.
object to going into anything the jurors may have believed. That would be inappropriate as well.
Sure.
And Judge,
Okay.
I'm just responding to the court's statement as to what the jury found. After speaking with jurors,
This
I
is
can
what the jury
represent,
found, this verdict form right here.
and I can represent to the court what their reasons are, and
That's the part I object to.
Sure, yeah, okay.
And I also think it's appropriate to take into consideration what they want, as far as they were the consensus of the community. They were the community speaking on the verdict and what they want going forward. I think that's appropriate. And
It's absolutely inappropriate for them to consider sentencing at all.
in their verdict, it is. It is. But the consciousness of the community is something that is appropriate for the court to consider.
Well,
And what
then
the
you could bring
community
every
wants.
person down here, not just the jury.
Definitely.
So, yeah,
No, without a doubt, Judge, and we
Well-
obviously don't want to do that. We obviously don't want to have to do that. So instead, we're arguing what the jurors who actually heard the facts of this case, because they're the ones that actually know everything that happened in this case. They're not the lawyers; they're the actual jurors in the case, and what they
I
heard.
don't see any of the jurors. Anyway, go ahead.
I don't expect any of the jurors here. Yeah,
Yeah, me either,
right.
but they're welcome.
Obviously,
All
yes.
of
No, they were definitely welcome. They're definitely welcome. Just one moment. Judge, but finally, just in summation, Ryan did not have to take the stand. He did. He spoke his truth. He spoke what happened in this case, and you could see true remorse. You could see that he is remorseful. He was remorseful this entire time. He suffered immensely from, and he's certainly not a victim, but his character is relevant for you to consider. He tried to commit suicide several times. He suffered from mental health issues. He suffered from drug and alcohol addiction. All of these things, and so I think that's important for you to consider as well as granting a sentence, Judge. And so he's been in a little over 5 years. The other thing that's important is that this would be considered under the 2005 sentencing guidelines, and as far as that, you're able to grant him first offender status. You're able to grant him first offender probation. So we would ask for a sentence that's along the lines of what the sentence that's appropriate in this case is what, essentially looking at the time that he would be serving. If you were to give him the maximum, the 10 years, practically speaking, he's eligible for parole, and he's already served twice what the parole guidelines state he would
The
serve.
parole board that's right.
Right,
They
right.
have their own rules, and
They do.
they can let him out anytime they want to.
Right, and so practically speaking, we all know as lawyers that, and the court knows that he's already served twice what that parole time would be. So if you give him a straight sentence, he will be, essentially, he would be parole eligible immediately.
That's
If
right.
you gave him a split sentence, you actually would then be able to impose conditions on him because you would have him on probation, where it's different than if he's just paroled out and is free to just walk out. So we would be asking that you give him a split sentence, 10 years to serve, well, he's already served 5 years, 5 years in custody, and then the balance on probation, and he'd be permitted to complete the First Offender Act.
Thank you so
Thank
much.
you.
Thank all of you for your contribution to this hearing. It's funny when you say, Ms. Merchant, we know as judges and we know as lawyers, about the parole board, or we know about the sentencing guidelines. But we don't know until today about the real impact of a person's actions. Compared to what you were acquitted on, Mr. Duke, this charge of concealing the death of another is minimal, no question about it. You had a great defense in the case. And that is what it is. And you should be punished accordingly. Not for murder, not for burglary, not for aggravated assault. Because that's the way the system works. And the community, you, the family, everybody has to live with that. Because we live in this country. That's the way our system works. But you don't know, really, what pain your actions cause until somebody reminds you that every day what they live with is they can't find terror. Every day they couldn't find terror. And it is true that despite whatever your selfish feelings were for not coming forward, you had the power to stop that pain for years and years. I agree. I think your testimony was remorseful. Every statement that I heard you make seemed very remorseful. And you should be remorseful. And it won't ever leave you, I'm sure, what you've been through. But it won't ever leave those people either until the day they die. Until the day they die. And they didn't do anything but love her. That's all they did, was love their friend, love their stepdaughter. That's all they did, their sister. And that cannot be minimized or forgotten. You know, whether the system works for some, doesn't work for some, it works for everybody. It doesn't get the system doesn't guarantee any result. The system seeks justice every day. And those jurors worked hard on your case, and they decided what was justice. And that's what it is in this case. And it's up to me to impose an appropriate sentence. And that sentence is 10 years to serve in the state penitentiary. You're right. The parole board may pardon him out today. Maybe that's the case. But that's the sentence of the court. You have 4 years from the date of the filing of the sentence to seek any state habeas corpus relief. 30 days from the date of the filing to file any notice of appeal or motion for new trial. Anything further? We'll be adjourned.